Welcome to Past Law Exams. This is part 2 of Consideration in our Contract Law series. Let's get into it. In part 1, Lord Coleridge, Chief Justice, dissented in Curry v. Mesa, 1875, arguing a pre-existing debt cannot be fresh consideration. That question has troubled the courts ever since. Today, we answer it. First, existing obligations. Performing a duty you are already bound to perform is not good consideration for a fresh promise. Stilk v. Myrick, 1809. Two sailors deserted mid-voyage. The captain promised the remaining crew the deserters' wages if they sailed home. They did. He refused to pay. Lord Ellenborough held the agreement void. The crew gave nothing new. That was the law for over 180 years. Then came Williams v. Roffey Brothers, 1991. Roffey subcontracted carpentry to Williams. Williams fell behind. Roffey, facing a penalty clause, promised additional payment to finish the job. Williams continued. Roffey refused to pay. The Court of Appeal held the promise enforceable. Roffey obtained a practical benefit. They avoided their penalty. They avoided finding a new contractor. Practical benefit, with no duress or fraud, is good consideration. Stilk v. Myrick was not overruled, but significantly refined. Past consideration. Past consideration is no consideration. A promise made after an act is already complete cannot be enforced. McArdle, 1951. Mrs. McArdle improved a bungalow belonging to her late father-in-law's estate. After the work was done, the beneficiaries promised to pay her £488. They refused. The Court of Appeal held the promise unenforceable. Her consideration was entirely in the past. But there is an exception. Lord Scarman in Pao On v. Lau Yiu Long, 1980, set out a three-part test. Past consideration may be valid where 1. The act was done at the request of the promiser. 2. Both parties understood it would be compensated. 3. That payment would have been enforceable if promised in advance. Narrow, but real. 3rd, Promissory Estoppel. What happens when a promise is made without consideration and relied upon? Denning J. answered that in Central London Property Trust v. High Trees House, 1947. A wartime landlord reduced rent by half in writing, no consideration given. By 1945, the flats were fully occupied. The landlord sought full rent going forward, and succeeded. But Denning J. said in obiter, had they sought the arrears from the war years, they would have been estopped. The principle, a clear and unequivocal promise, intended to affect legal relations, relied upon by the promisee, cannot be acted against inconsistently. Promissory estoppel is a shield, not a sword. It suspends rights. It does not extinguish them. Before you go, your recap checklist. 1. Performing an existing duty is not good consideration. Stilk v. Myrick, 1809. 2. A practical benefit to the promiser can make a promise enforceable. Williams v. Roffey Brothers, 1991. 3. Past consideration is no consideration. McArdle, 1951. 4. Past consideration may be valid if Lord Scarman's three-part test is satisfied. Pao On v. Lau Yiu Long, 1980. 5. A promise relied upon may be binding even without consideration. Central London Property Trust v. High Trees House, 1947. Write those down. Know those cases. Apply those principles. Want to test your knowledge? Visit us at pastlawexams.com. Past paper questions, model answers, and everything you need to prepare. Pass law exams. Because passing is the only option.